Good morning, everybody, and thanks for joining us today for the February 2020 installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these monthly as a quick update on timely issues in environmental law, and there seem to be a lot of timely issues these days. I'm Ann Navaro, and along with my colleagues Sara Burgin and Daniel Pope in Austin, we're here today to discuss the recently released final definition of waters of the United States under the Clean Water Act. We're going to cover these agenda items in about the next 30 minutes. And if you have any questions as we go through this, you can type them into the comment box on your screen, and we'll get to any questions that we have at the end of the webinar. If we run out of time, we can always follow up with an email with respect to your particular question. So the administration released the final revised definition of waters of the United States on January 23rd. It has not yet been published in the Federal Register. As I think everybody on the phone knows, the Clean Water Act provides regulatory authority over the navigable waters of the United States, which are defined as the waters of the United States, including the territorial seas. The statute is implemented by both the Corps of Engineers and the EPA, and the meaning of waters of the United States, or the geographic reach of the Act, has great significance for a host of public and private activities. In fact, I view this as one of the most significant rulemakings to come out of the Trump administration. Courts, landowners, agencies, and land users have struggled with this definition for decades. The Supreme Court has infamously thrown up its hands in one of the more recent decisions to make it to the court, the 2006 Rapanos decision, which is the last one that really looked at the meaning of waters of the United States. And in that decision, the court came up with a muddled result with two potentially applicable standards. So the Obama administration made a run at trying to straighten out the definition and promulgate a new one, but it resulted in a rule that only went into effect in about half the states because of complicated litigation, and it was characterized by many as broadly expanding jurisdiction and making it more confusing rather than less. In fact, I think the whole saga of waters of the United States, in addition to the efforts by the Obama administration, this administration, and all the litigation, certainly would make an excellent law school class on federal jurisdiction, the scope of injunctions, the reach of the Administrative Procedure Act, and a variety of other issues. So just briefly, what's in place currently? Because the proposed definition has not yet gone into effect. Currently, the regulations from the 1980s are back in place. They have been implemented in accordance with three Supreme Court cases based on policy guidance issued by both EPA and the Corps of Engineers, and they are now in effect in the entire United States following the repeal of the 2015 Waters of the U.S. definition. They went into effect, or back into effect, in late December, and although there is litigation, the repeal rule has not been stayed. Assuming this new 2020 rule goes into effect, once it's published in the Federal Register, it will replace the rule that's currently in effect from the 1980s. So obviously there's a lot of moving parts with respect to the new definition of waters of the United States, and the federal government's explanation of the basis for that rule is critical to both understanding it as well as defending it in the litigation that is sure to follow. So there have been a number of consistent themes in this administration's various forms with respect to regulation, and one of those most consistent themes is the desire to turn authority back to the states. And that's certainly one of the central principles underlying this rule, that the federal government intends to stay far away from the murky edges of its Commerce Clause authority and its power over navigation, and narrowly construe federal jurisdiction and make sure that the states have primary authority over what the federal government views as local land use decisions. Of course, this new definition will also recognize and take into account 3 important Supreme Court decisions, which probably people on the phone are very familiar with because they've been around and influencing this discussion for years. And they are Riverside Bayview, Swank, and the Rapanos decision. So what the final decision says is that this new rule takes into account and is based on the commonalities between those decisions and their emphasis on the need for there to be a meaningful connection between what's considered a traditional navigable water and other waters that may be subject to regulation. One question that Daniel will talk about a little bit later, is whether litigants may contest that the administration has relied too much on legal and policy interpretation without significant science to back up the new definition. And that's important because we need to keep in mind that the Clean Water Act expressly is concerned about the chemical, biological, and physical integrity of the nation's waters. And this is definitely something that's going to be a tension in litigation. So what the administration has tried to do is identify the line that was talked about in the Supreme Court decisions. Where is the jurisdictional line? It's somewhere between a water that you can float a cruise ship on and dry land. And in the effort to find that line, the preamble to the final rule certainly reads like a law review article as it goes into the various court decisions and the background of the Clean Water Act. The Riverside Bayview case first really started talking about whether a water that might be subject to federal jurisdiction really would have significant effects on downstream water quality or the water quality of traditional navigable waters. And so that's where this concept is rooted. In this rule, the administration has chosen to construe those Supreme Court decisions and other precedent narrowly at every turn and to weigh more heavily the Supreme Court language that points to a less broad interpretation of the Clean Water Act. So the administration has simplified waters that would be considered waters of the United States into 4 categories. And again, the policy key behind this formulation is to preserve the primacy of states and tribes on tribal lands for ordinary land use decisions and to take the federal government out of land use decisions with respect to waters that do not have a connection, an adequate connection to a traditional navigable water. So some questions that have been raised is whether this approach will increase the financial and administration burden for states, and that's something that the regulated public could certainly see as this moves forward, if that's the case, and whether it might also undermine the purpose of degrading waters that have an effect on the health of more permanent waters of the United States or traditional navigable waters. And that's certainly something that will come up in litigation. So what are the waters covered under the rule? There are 4 very straightforward categories. There are traditional navigable waters, which are territorial seas and waters that may be used in interstate or foreign commerce, including waters subject to ebb and flow of the tide. There are tributaries, but these tributaries are rivers and streams that contribute surface water flow to traditional navigable waters in a typical year. So it's not all tributaries. Now there's got to be a more meaningful flow than under the current rule. So just for comparison's sake, the current rule that's now in effect from the 1980s affords the federal government more discretion over jurisdiction in a number of ways. For example, the rule from the 1980s currently claims jurisdiction over water used by interstate or foreign travelers without any reference to navigable waters. So part of the aim of this new definition is to afford even less discretion in terms of federal jurisdictional reach than currently exists. The 3rd and 4th categories of waters that are covered under the final rule are lakes and ponds and impoundments of jurisdictional waters, and finally, adjacent wetlands. But again, the basic premise of these categories is that there has to be a contribution or a physical connection between these categories to a traditional navigable water in a so-called typical year. And the phrase typical year is key to the reach of the new rule with respect to jurisdiction. Typical year is defined to mean when precipitation or other climatic variables are within the normal periodic range for the geographic area of the applicable aquatic resource based on a rolling 30-year period. So the administration, the preamble summarizes that standard as, look, we just want you to assess these waters under conditions that are not unusually wet or unusually dry when assessing whether something is jurisdictional. So, of course, a key question for the regulated public is, will the final rule be simpler to use than the rule that is now in effect? In some respects, I think the answer is certainly yes. It eliminates the so-called significant nexus inquiry for individual waters. That's the inquiry that came out of the Rapano Supreme Court decision, where for some waters, for example, the Corps of Engineers would have to conduct a significant nexus analysis to determine whether the potentially jurisdictional water had a significant nexus from a chemical biological perspective on a downstream traditional navigable water, so kind of a science project. So that consideration is no longer in the new rule, assuming it goes into effect. In terms of additional complexities that the new rule may add, there's the proposed definition of intermittent, which means surface water flowing continuously during certain times of the year. And then there's a definition of typical year, which I just mentioned. And both of those add some complexity that requires certainly some level of scientific analysis that are a little more or different than what's in the current rule. The definition of typical year in the proposed rule clarifies that the range doesn't have to just be based on a calendar year. It just has to be at times that aren't too wet or dry. The preamble notes that some people suggested that the geographic area to which the typical year inquiry applies, that the government should specify the watershed size where that analysis is made so that the regulated public would understand the parameters of the inquiry. The government rejected that, saying if we specify an actual watershed size, that could preclude the use of best available data, but watershed boundaries should be a consideration. So there's still going to be a lot of scientific inquiry and analysis that goes into a jurisdictional call with respect to waters that aren't clearly traditional navigable waters. And just to mention one other aspect of that inquiry, with respect to the definition of intermittent, the government suggests that that means extended periods of predictable continuous flow that are year after year. But importantly, in the preamble, the agencies expressly note that intermittent doesn't mandate a constant groundwater connection, which is actually an element of many scientific definitions of intermittent or perennial. So this definition of intermittent, the government says you could rely just on melting snowpack as long as it's predictable continuous flow year after year, even without a groundwater connection, which I think is a significant difference. So now I'm going to hand it off to Ms. Burgin to talk about types of waters that are excluded. Sorry, everybody, we seem to be having technical difficulties. Stand by for 1 second, please. So this is Ann Navaro. We're going to have Austin sign off and dial back in. But in the meantime, for those of you who've had the patience to hang in with us, I wanted to make a couple comments about waters that are excluded under the final rule. And then hopefully we will have Sara Burgin back on and Daniel Pope to talk about some of the differences between the proposed rule and the final rule. Most significant, and this is a continuation from the proposed rule, the final rule excludes from federal jurisdiction ephemeral features. This is not only a significant difference from the Obama era rule in 2015, but it's also a difference from the current rules that are in place that are based in the 1980s and subsequent Supreme Court decisions. Ephemeral features, the exclusion of ephemeral features from jurisdiction has significant implications not only in the arid Southwest, where it may mean that permits are no longer required, for example, from the Corps of Engineers for fill of certain swales, gullies, and dry washes, but it even has significant implications for places elsewhere in the country where the Corps of Engineers has undertaken permitting for fill of ephemeral features that are high up in a watershed. So, for example, in Appalachia, where there's been a good deal of surface coal mining, many of the permits that the Corps issued related to that surface coal mining was for the fill of ephemeral streams that are high up in the mountains in Appalachia. So removing ephemeral features from jurisdiction will have significant implications across the country, and I certainly expect that to be heavily litigated. Do we have Austin back yet? All right, so we don't have Austin back yet, so I'm going to talk a little bit about some key changes in the final rule that did not appear in the proposed rule, but were a result of additional consideration by the federal government and no doubt a result of active comments from the public. The final rule clarifies that tributaries that are linked to a downstream traditional navigable water through channelized features can be jurisdictional, even though the connector feature is not. So just because there's some interruption in jurisdiction, as long as there is still some meaningful surface flow in that upstream tributary to a traditional navigable waters, that upstream tributary will still be jurisdictional. And that even applies where, for example, you might have an intermittent tributary that disappears underground or goes through a boulder field or something like that, but then still has that connection to the traditional navigable water. There's still jurisdiction. So even with the efforts to make the rule as crystal clear as possible, it is still going to involve some level of field assessment and clarity. The final rule also clarifies that adjacent wetlands are entirely jurisdictional, even if they are divided in part by a man-made structure. So even construction of a man-made structure under this new rule doesn't necessarily terminate jurisdiction, as long as, again, that structure allows for a direct hydrologic surface connection in a typical year. So we are back to that use of that typical year standard, which is critical in most aspects of this rule. I think we have Austin back. So Sarah, would you like to proceed?
Good morning from Austin. I think Ann has basically covered pretty much all of the material relating to the key changes to the proposed rule. And I think we should perhaps at this point go straight to Daniel and have him talk about the litigation landscape and what we can expect going forward.
And thanks, Sarah. I think it's about time to talk about our nation's greatest pastime. I'm not talking about baseball. I am talking about WOTUS litigation. A new season is about to start. Can you feel the excitement? Let's look at the arguments. Let's look at the players. Now, Ann mentioned that as a result of the repeal rule, we have the 1986 regulations in place. So that means that our understanding of WOTUS has to account for what application of those regs in a post-Swank, post-Rapanos world would look like. If you're feeling like we're in a very niche legal version of Back to the Future, you may be right. This Step 1 repeal has been challenged in the Southern District of New York by a number of states, arguing that repealing the 2015 rule and moving back to the 86 regulations is inconsistent with Supreme Court opinion in Swank and Rapanos. So it's basically an Administrative Procedures Act arbitrary and capricious challenge. Motions haven't been filed, but we expect those to be filed in the Southern District of New York on March the 5th. And that's going to give us more clarity on what the arguments challenging the repeal will be. But what about the Navigable Waters Protection Rule itself? Well, you'd have to be living under a rock to not notice how many NGOs were immediately critical of the 2020 rule, both when it was proposed and when the final rule was announced. We can expect a lot of the usual suspects to challenge this rule, which will probably include states like New York and the others that have joined the New York versus Wheeler lawsuit on the repeal rule. What will those challenges look like? Well, as Anne previewed for us, there's going to be a challenge to the departure from the significant nexus standard, which after all lends itself to fact-intensive hydrological inquiries and disputes. New York is actually already making this argument in the 2019 repeal challenge, and we expect that that's going to be a major challenge to the 2020 rule. This is why Rapanos being so fractured was detrimental, and why the case will have to continue and it will continue to have lingering effects until a new case supplants it. I would expect that a lawsuit under this rule will likely go to the Supreme Court, and the Roberts Court will have another opportunity to get to 5. And that may be easier with Justices Thomas, Alito, Gorsuch, Kavanaugh, as well as Chief Justice Roberts himself, on record expressing skepticism about WOTUS regulations in the intervening period. We might expect them to have a more straightforward rule of law approach. And the odds of a challenge to this rule increase dramatically if the current administration continues. So at any rate, don't retire all of your WOTUS, POTUS, SCOTUS puns. The fundamental dispute over the Clean Water Act, as Anne mentioned, is going to be whether legal categories dominate jurisdiction or whether scientific principles dominate jurisdiction. Legal and jurisdictional categories and federalism were among the main theoretical justifications for this rulemaking, whereas the 2015 rule embraced a more scientific approach. After all, the purpose of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters, right? So how might that purpose statement be used in new litigation? That's going to be something we're watching, and we can expect to see a number of cases, a number of complaints, saying that the rule, the Navigable Waters Protection Rule, is inconsistent with the purpose of the Clean Water Act. And we can also expect to see a lot of citations to a letter to Administrator Wheeler from EPA's Scientific Advisory Board in these lawsuits. That letter, drafted and sent late last year, says that elements of this new rule are in conflict with established science. The existing WOTUS rule develops based on the established science and those Clean Water Act objectives. Now, I didn't mention this on the slide, but we can also probably expect some challenges about the process employed by the agencies in the rulemaking, or whether a change in the final rule was properly noticed in the proposed rule. And don't forget that there's a possibility of challenges from the right. Landowners, businesses, or property rights advocates may be frustrated that the ghost of the significant nexus test still lingers. For example, tributaries connected to a traditionally navigable waterway, even if there's an ephemeral feature between them, there will still be WOTUS jurisdiction over that upstream tributary. So potential plaintiffs that were hoping to be WOTUS free in the new year and are not may also challenge the rule. Thanks, Anne, and back to you.
Thanks very much, Daniel, and thank you everybody for tolerating our glitches this morning. We really appreciate it. That's all for this morning, and we look forward to talking to you all in about a month. Thanks very much. Bye.